Okay, let's get started. Good morning, everybody who's in the California area. Good afternoon for those of you in the New York area or East Coast, and good evening for those of you who are in Europe or England or further east. We're very happy today to be able to speak to you about the actually very interesting area of international litigation funding for collective procedures. Before we get started on some of the technical aspects, we'd just like to say that we're really heartbroken that Chris Kimmickles is not able to be with us because he died over the weekend. Ariel mentioned that at the very beginning. Jeremy, when he does join us, is going to say a few more words, but I do just want to say that we're absolutely heartbroken that Chris is not here. Before we start, let me just say, we'll give a little bit of introduction about ourselves. I actually have three hats on today. First of all, I am the president of Global Justice Network. That is a group of international claimant counsel. In the US, we call that plaintiffs, but in England, claimants. And we actually work together on international cross-border cases. We're not an academic organization. We're a real working together organization trying to progress different types of cases. We have experts in aviation law, maritime, data breach, products liability, financial disputes, financial securities, human rights, workers' rights. We have basically experts in lots of different areas. Secondly, I am a lawyer with PGMBM. That's a law firm that's based in London and has an office in Liverpool, multiple offices in Brazil, and we have just opened up an office in Miami, Florida. That is our first office in the United States, and I'm very happy to be leading that office with some tremendous young, dynamic attorneys. My third hat is I am an advisor to Pure Equitas, which is a litigation consulting business. So it's not a funder, but we offer consulting services in the litigation finance sphere. Let me introduce you to Maya. Maya, please tell us a little bit about yourself before we get started.
Thank you. I'm a law professor at the University of Iowa College of Law. I have researched and published extensively on litigation and law firm finance and have for about a dozen years now. And I also write on class and mass actions, especially transnational ones. So that's my main capacity, but also I have served over the last decade or so on multiple occasions as counsel, consultant, or expert witness in various types of litigation finance related matters. So I do bring that perspective as well.
That's great. So Jeremy is going to join us hopefully soon, but before he does, why don't we just start off with you, Maya, explaining a little bit about litigation financing, and with your background, I think you're well placed to tell us about what's going on in the United States.
Again, thank you very much, Melissa, and thank you for the organizers for inviting me and for putting this very timely panel together. So our panel, in fact, is diverse, and I've been asked to talk about the American perspective, and what I'll do is I'll divide my comments into three parts. The first part will be just basically the most important current developments here in the US in this area. The other will be a survey of what's happening on the regulatory front, which is very dynamic, fluid, and interesting. And finally, depending on how much time I have, is a little bit of my projections of what I think we'll be seeing in the short and intermediate term in the US, both empirically, what will happen with the industry, and also on the regulatory front. So that's my plan. In delving right into the first, again, topic, some important market developments here in the US. So the first thing I would mention is the biggest shift in the last 3, maybe 4 years has been the shift from funding single cases to funding portfolios of cases. And this changes entirely the economics of the deal, the dynamics of the deal making, and also then the monitoring of cases has different sort of ethical and regulatory implications. and I think sets us up into having litigation funding be a force that really transforms the legal profession in the US in coming years. So that's the first thing, is the move to the funding of pools of cases or portfolios of cases. The other thing that we've seen recently is the rise of funding of class and mass actions. Now, in some other jurisdictions like Australia, litigation funding arose in order to fund exactly those kinds of cases. But in the US, it's been reversed. And in fact, it's fascinating to me as someone who has been on the front lines of this industry since it emerged in 2008, is to have seen the shift both in terms of what market players are doing and how the environment is responding, the legal profession, the judiciary is responding to it. Because when I was doing these panels 10, 11 years ago, a major talking point for the funders in the US was to say, we will never fund class and mass actions. That's not the kind of cases that we will ever get into. And it was a big political issue. The US Chamber of Commerce has and remains opposed to litigation funding precisely because of their worry about how it will empower plaintiffs in this context. So it's happened, it's here, and it's happened despite the fact that at least theoretically there's some insurmountable hurdles that we used to talk about a decade ago. And the third important and exciting development on this side of the pond is that Burford Capital has recently gone public and listed on the New York, the NASDAQ. They've been publicly traded in the UK, but they're the first ones to make that shift here in the US, and that's going to, I'm sure, have repercussions on what goes on here in the coming years. So those are sort of the main developments that I want to report to you. And now I want to move on and talk a little bit about what's going on at the regulatory front, which is, I said, very, very active and moves in various directions. So by way of overview, I'll just note that the regulatory developments are moving simultaneously in two opposing directions. Namely, on the one hand, we're seeing a liberalization and a growing acceptance and a facilitation of litigation funding. And on the other hand, we're seeing attempts and actual moves to regulate the industry, which of course restricts at least how it operates, if not whether it operates. So I want to unpack that a little bit, and I'll address three types of regulation that you should think of if you're going to engage in litigation funding in the US. And the first will be champerty, which traditionally is the traditional doctrine that used to, or where it still applies, prohibits entirely litigation funding. The second is disclosure, a huge debate here in the US on whether to disclose, to require disclosure of litigation funding, and if so, how much needs to be disclosed to whom and at what point in the process. And the third sort of regulatory category is what's happening with the fee sharing prohibition. So in the US, lawyers are regulated on a state-by-state level. In 49 of the 50 states, because Arizona changed its laws very recently, as I'll explain, have a prohibition on lawyers sharing fees with non-lawyers. And this is critical for litigation funding because it is what has traditionally forced funders to contract directly with the clients, with the plaintiffs, as opposed to contract with the law firms, which for a variety of logical reasons they'd rather do. So there's changes in the fee sharing landscape. So let me go into a little bit of detail under each one of these headings. So in terms of champerty, again, if you're not familiar with the US landscape, you may be surprised to learn that almost half of the states in the US actually still have a champerty prohibition, and litigation funding is not allowed. However, what we've seen throughout the last, again, dozen years or so is many states liberalizing their champerty laws, either expanding their exceptions that do allow for third parties to fund someone else's claim, or even in the most recent and exciting development in the state of Minnesota, eliminating the champerty prohibition altogether. So again, Minnesota is the most consequential development here. And about a year ago, the Supreme Court of the state just got rid of Champerty, opening up that jurisdiction to third-party funding. On the disclosure front, there's so much to say. I'll restrict myself. I have provided a recent article that I wrote on this topic to the organizers, and they're going to link it after the event to the website. So if you want to know more, you can find it there. But it's a very fluid and quick-moving situation with regulation of or the potential or actual requirement of disclosure of litigation funding. And we're seeing activity on both the federal and the state level. At the federal level, there's a bill pending in the Senate Judiciary Committee that, if passed, will require disclosure of litigation funding in class and mass actions. And in the last portion of sort of the future telling part of this talk, I'll say a little bit something more about that. But Congress has an interest, or at least some members of Congress have an interest in potentially regulating third-party funding, at least in the class and mass action context. We also have an entity here called the Advisory Committee on the Civil Rules, and that's a committee comprised of federal judges who basically advise the Supreme Court on whether and how to modify the federal rules of civil procedure. And it has been on and off for quite a few years now, examining the question of whether the federal rules of civil procedure need to be modified to accommodate in multiple ways, including on the issue of disclosure, the rise of litigation funding. And so as of late, they have said once again, not yet. We don't feel like we need to step in, but it's on their agenda. They think about it. And, you know, I think in the future, we may see some changes to the rules of civil procedure. And finally, as Congress and the Rules Committee are taking their time, district and appellate federal courts have been operating locally and issuing local rules. So each district and even each court can, and even each chamber can sort of establish their own rules to some extent. And some have just gone ahead and said, you know, I'm going to require disclosure under these circumstances and so forth. So if you're practicing in the US or investing in the US, it's a real patchwork in terms of what you need to be following on the disclosure front. States have also looked at the regulation of litigation funding generally and disclosure specifically. By and large, what states have done is actually show no interest in the funding of commercial cases or even class actions. Where they have been very active for at least a decade now is in consumer funding, the funding of small consumer claims, where they've basically imported consumer protection measures and applied them to litigation funding to prevent practices that are similar to predatory lending. But also in April of 2018, the state of Wisconsin became the first one to enact a state law requiring litigants to disclose their outside legal funding arrangements. So again, as the federal regulators and legislators are taking their time, the states are starting to move a little bit. Finally, and I think most importantly, is what's happening on the fee sharing front, namely whether or not lawyers can contract directly with funders, which of course economically makes the most sense. And as we know, the law doesn't necessarily follow economic reason. So what we've seen here, first of all, is in 2018, the New York City Bar Association, which is not the New York State Bar Association, does not regulate lawyers, does not create law, but nonetheless, it's an influential body, came out with an opinion that sort of sent shockwaves throughout the New York legal profession and beyond, opining that these portfolios of cases that I mentioned at the outset violate the fee sharing prohibition. And this created such an uproar that it reconvened a task force to look at the issue again. And that task force, the second one, essentially reached the same conclusion in terms of what's the state of the current law, but at least moved the discussion forward by calling to change the law to allow fee sharing, but that's out there, and that's very consequential to especially lawyers in New York. Meanwhile, on the west side of the continent, Arizona went ahead and in August of this year, the Arizona Supreme Court issued an order eliminating Arizona's fee sharing prohibition. And so that's a very important development. Very possibly other states will follow suit, and some are looking into it. So California and Utah are actively considering now the same measure that's happened in Arizona, sort of liberalizing and making it easier for lawyers to engage in this kind of arrangements. And the city of Chicago and Illinois, their bar organization, is also looking at the issue last time I checked. So those are the regulatory developments. So as you can see, it's very active. There's a lot of interest in the bar, in the judiciary, and in the various legislatures as this industry grows. And I'm going to spend my last 3 minutes gazing into a crystal ball and making some predictions that may come back to haunt me if they don't materialize. But here's what I think those of us who are interested in this area want to be keeping an eye on. So first of all, this is an easy one. We're going to see a continued expansion of litigation funding. I think there's going to be more money coming in, more investment in existing categories, as well as new categories or types of cases garnering interest. And I think that is the case both because there's a growing acceptance of the practice in the US, a growing clarity on the state of the law. For example, states clarifying that certain arrangements are not champertus, it's okay, you can go ahead and engage in them. And I also think it's because of the economic crisis we're in. So we saw the watershed moment that kind of allowed this industry to emerge in the US was the previous crisis of 2008. We have another economic crisis. Investors are looking for assets to invest in that are not correlated, and litigation is actually counter-cyclical. When the economy goes down, litigation goes up, at least in the US. So I think we're just going to see a continued expansion. I think, and this is where I'm going to go out on a limb, so I'm going to really qualify. I don't know that the following is going to happen, but I think it would be interesting to watch whether, due to the results of the election, we will actually see some activity, some legislation coming out of Congress. If you had asked me even as little as 2 weeks ago, I would have told you that that bill in Congress is dead and it's going to stay that way and cannot be resuscitated. But I actually think we may see a strange alliance given the composition that's emerging in Congress, where Republicans would want to regulate this because they don't want funding of class and mass actions. And Democrats might want to regulate this because they like regulating the financial industry. And those may actually converge. So for me as a geek, it's exciting that that prediction is possible. I would not have seen this coming as little as 2 weeks ago. We're going to continue seeing a patchwork of regulation of the question of disclosure, whether, when, how, and to whom litigation funding needs to be disclosed. There's going to be more of it. It's in the pipeline. It's going to be all over the place, and it's going to give lawyers a lot of work figuring it out and advising parties about that. We're going to see, I think, very interesting scenarios coming up in federal courts in the aggregate litigation context. So since we're starting to see more and more funding of class and mass actions, we will see more questions about the regulation of litigation funding in those contexts. It's an unusual context for American courts, where courts do step in and scrutinize what the lawyers are doing, kind of contrary to what they otherwise do. So I think that we're going to see some cutting edge decisions on litigation funding coming from the courts through the context of class and mass actions. And I think we might start seeing, because of Burford's new status, we might see investor protection regulation coming in, which we have not seen, at least in the US, of the industry. So I'll pause here with my prognostications, and I will hand it over back to Melissa.
Thank you, Maya. Jeremy still has not been able to find his way into this program, into our speakers panel, but I'm wondering if he's in the audience, if he could simply click, there's a button where you can say, share my audio and video, and join the panel that way. I raise that as a possibility.
Hi guys, sorry to jump in because I heard with regards to, I just want to give an update to the speakers, but also to the audience with regards to Germany. I'm not sure if he will be able to join this panel. Something came up.
Okay.
However, as a representation of Omni Bridgeway, his colleague Noah Wortman will be later on another day in another panel. So the audience will have an opportunity to get a flavor of what Omni Bridgeway does and how it can help them moving forward. However, I strongly believe that between Melissa and Maya, who just stopped giving a lecture, I believe, for a couple hours before she joined us, we have the right tools at hand to continue to engage our audience. And I can see that they're engaged because apart from 2 + 2 and -2 people coming in and out, everyone still seems to stay on live within the session. And everything that you guys have said will be recorded and can be used at a later stage as well for the next 12 months. And we might edit it in terms of adding something on behalf of Germany at the recorded session of that later stage. I'll let you guys continue. I just wanted to say something with regards to.
Okay, thank you, Florian. I appreciate that. Okay, now I'm heading basically towards Miami, but I've been living in continental Europe for decades. So my perspective is going to be complementary to Maya, more talking about what's going on in Europe. But first, let me just say, I was asked to speak on litigation funding from a lawyer's perspective, which is really what I consider to be the fun part. So let me first talk about from the claimant perspective, naturally because my perspective is from Global Justice Network, that is from the claimant perspective. The biggest advantage we see from litigation funding is access to justice. Quite frankly, there are cases that we would not be able to bring if we were not able to get funding. So it levels the playing field. Often the cases are brought against massive major corporations who have the money to pay for defense, and often the plaintiffs don't. So it really helps us a lot. Also, we need in litigation not just to run a short sprint, but we need to be in for the long haul, the marathon. And also, we find that if we have litigation funding, it acts like a seal of approval to our litigation, because the defendants will know that the litigation funder will have looked at the case from multiple different angles. And if we have litigation funding, then we know that we have a good solid basis for a case. That doesn't mean we're going to win, but that means that we at least have the funder seal of approval. The other thing that I think is advantageous with regard to funding is often the funders, when they evaluate cases, will be able to give us insight that we as lawyers may not have. They tend to be, think along more of like business lines, which makes perfect sense, looking at return of investment and things like that. So it's also helpful in that regard. And I think also if you have a case that is being considered for litigation funding, that requires you to really seriously organize your case right from the beginning. You have to be able to take a look at lots of different factors, not only the law, but different, let's say, phases of the case, how things could work, how things might not work, etc. So having litigation funding actually forces you at the beginning and throughout the case to have a well-organized case. Now, I can't speak too much from the defense perspective because I haven't worked as a defense lawyer in decades. I used to work in medical and practice defense, but that was a long time ago. But from what I understand, litigation funding has its role on the defense side because it helps with cash flow management. Also, there might be some taxation benefits that could be considered. Now, the downside of litigation funding is obviously when we win the case, and of course we do plan to win, then we have to share the profits with the funder, which only makes sense. And quite frankly, there is also some extra work that has to be factored in for keeping the litigation funder appraised of what's going on in the case. So those are basically the downsides. Now, what are the options for funding international collective proceedings? If you were on the first panel, you heard Joe Salveri talk about how U.S. plaintiffs' lawyers are essentially, for the most part, funding their own cases. When maybe they take the risk using the contingency fee agreement, and if the case is successful, then obviously they win the case. And Joe pointed out their U.S. lawyers aren't that worried about having to pay the other side's cost in the event of loss, which is a factor that is not the same in other jurisdictions. For example, in England and Wales, there is a significant risk of paying the other side's fees in the event of loss. So there's the U.S. contingency fee basis where the lawyers basically fund the litigation themselves. There's also private third-party litigation funding, which Jeremy would have told us more about from the standpoint of Omni Bridgeway, but we can go into that later if we have time. There's also public collective litigation funding. I understand in Quebec and in Ontario, there are public litigation funds that actually work to fund class actions. And then there's a small number of cases that are funded by crowdfunding. For example, Crowd Justice is a platform that does use crowdfunding in order to fund litigation. These are typically often cases that maybe have a political aspect to them. Now, what are the trends in Europe? In general, litigation funding is growing. It is becoming increasingly accepted. Now, not every jurisdiction does allow litigation funding. Ireland sticks out as the main jurisdiction that does not allow it for reasons of maintenance and champerty. But over about the last 10 or 15 years, there has been a growing shift towards acceptance of litigation funding. And that kind of comes hand in hand, goes hand in hand with the European Union's discussions on collective redress. Notice that the word mass claims or class actions is a no-go in the EU. They don't like our US style of class action litigation, and they prefer to use the term collective redress. The European Union has more or less weakly meaning like not strongly, supported collective redress over the last 15 years, but it hasn't really taken off. Now there is a new directive that should be coming into effect next year sometime. Then there'll be some phase-in time for that. And that is a directive that will ensure representative collective redress in every member state. Now, there have been various versions of this directive, and at the moment it seems to be that litigation funding is more or less watered down. So there's not going to be necessarily a right to have litigation funding. There was a position paper of the EU Council upon the first reading of the directive that was just published about 10 days ago. And in that, they say that you have to ensure that the needs or of the consumers are not basically taken over by third parties. And by that, they mean the litigation funders. And they talking about disclosure that Maya was talking about before. The council says that in the case of justified doubts, the qualified entities may have to disclose their funding arrangements to the court or to the administrative authority. Also, the council has agreed that member states are to take measures that aim to ensure that the qualified entities, and by that they mean like consumer organizations, have the means to seek injunctive relief or can seek redress measures. What that's going to mean in the end, I'm not really sure. It could well be that this isn't the start of maybe some public funding in different member states. For example, in Germany, the consumer organization, the main umbrella consumer organization, does receive federal funding from the German government. Now, let me talk about the Netherlands. That's a very interesting place for purposes of collective redress for a number of reasons. For years, and I'm not going to go into a lot of detail because I know this will be addressed by other panels that are far more qualified than I to speak on this, but because the Netherlands does offer the mass settlement, there is the ability to have cases centered in the Netherlands, and it, I think, is an interesting area for collective redress going forward in the future. In fact, we can now see some US law firms acting essentially as funders in foundations and companies that are being set up in the Netherlands. So watch this space. I think that this is something that's going to continue to grow. And interestingly, in the Netherlands, the lawyers may not represent clients on a contingency fee basis, so the lawyers who are actually pursuing the case. But the foundations are able to basically take a share in the end in the event of a positive result. Also, in the Netherlands, the cost in the event of loss are not as drastic as they are, for example, in England and Wales, because it's statutorily based. And that, I think, makes litigation in the Netherlands somewhat interesting. Now, in Germany, I'll mention a little bit about how Germany has evolved over the years. Basically, there has been litigation funding since about 1999, but it hasn't really taken off. The Volkswagen case has triggered off some changes. First of all, in general, in Germany, there has not been the ability to take cases on a contingency fee basis. That has been somewhat permissible in some types of cases over time and over the last couple of years, and from what I understand is going to change going forward. But there have been some legal service companies, for example, Flightright, that was even before the Volkswagen crisis, taking cases that were, let's say, airline flight delays, and they could take those cases on a contingency fee basis, working essentially on an assignment model. And they also became involved in the Volkswagen diesel emissions cases on the same basis. In the year 2018, though, the German government made a test case proceeding called the Musterfeststellungsklage, or some people call it MFK for short, which is basically a case where a consumer organization can file a test case proceeding, and once it's filed, then people who are individually affected can basically sign up and put their names on the roll for this case. It is a case, though, that only gets you as far as a declaratory judgment. It does not address the issue of damages, or quantum, as they call it in England and Wales. There was a German case filed that was one of the first major cases filed using the Musterfeststellungsklage, and that case was settled in the spring of this year. And I think it's an interesting study. It could be basically like a whole panel discussion just in and of itself of what actually happened in the framework of this Musterfeststellungsklage. I won't go into details with regard to that, but I will say, though, that what I consider to be a failure of the Musterfeststellungsklage has also prompted some other private funders to get into the business in Germany. So I think going forward, you can take a look at Germany. I think there will be some changes that will be happening there. I want to just go through some practical tips for those who are seeking funding for their collective cases. First, do your homework. Know your case. Figure out what your funding needs are. Figure out what your funding needs are going to be for every phase of the litigation. Secondly, having a great idea is not good enough. You actually need to have clients. Don't go to a funder saying, "Oh, I got a great idea." That will be really frowned upon. Funders really also like to see that the lawyers have skin in the game. They understand that in some jurisdictions, lawyers cannot represent clients on a strictly contingent fee basis. Nevertheless, they want to somehow have the lawyers tweak the situation so that the lawyers actually have some skin in the game, so that when they win, they win. Either take cases in the area that you're really competent and proficient, or collaborate with another lawyer or law firm that has a track record in the type of litigation. Next, put together a very well thought through, concise, and justified package for the funder. Be prepared when you present your funding package to the potential litigation funder, and don't just go to one, go to several. Be flexible and seek flexibility, because in some cases you may be able to tweak a funding arrangement based on, for example, the number of clients you're able to attract to the litigation. And the next piece of practical advice is if you need help putting your package together, do seek outside help. There are consultation services available. And like I mentioned, I'm an advisor to Pure Equitas. This is the kind of thing that we do. So basically that's it for the practical tips. Now I'm going to go back to Maya and make sure that we're actually have answered the questions we were asked to answer. And quite frankly, I think we didn't answer any of them. So now is a good chance for us to do that. First of all, Maya, question number one is, how much money can we expect to raise in litigation funding?
You mean an individual case, or are you asking what's the volume of the industry?
No, an individual case.
In an individual case, if the case is meritorious, a funder will fund all of it, either itself or through a consortium if the case is really big, no matter how large the case is. And in fact, we've seen the early sort of incursions come through the largest cases, not as well as the smallest cases, which can be sort of managed on a volume basis, but actually huge international investment arbitrations where billions of dollars are at stake are attractive. So the size of the case and correspondingly how expensive it is going to be to pursue it is not a deterrent, and it may be in fact attractive. The issue for funders is this a meritorious case? Are you likely to win it? Am I going to be able to get a return on my large investment?
Mm-hmm. Okay, the next question, which again posed to you, sorry about that, is how involved are the funders? Do they get to say how the course of litigation should go, whether or not, for example, you settle, whether or not you appeal?
Yeah.
How does that work?
Yeah, there's really a broad spectrum here, and there's two considerations. Contractual, from the, I guess, plaintiff and the law firm's perspective, there's two considerations. What does the funding contract say? And where do you kind of bounce against regulation issues? So I'll talk about both of those, but I'll also say there's a third layer of consideration for the funders. It's not actually the case that all funders want to be active and to manage. So let me kind of just quickly go through all of these considerations. Generally speaking, in the US at least, the funder can be as active or as passive as they contract into. But however, there is a limitation on that, and which is if under the rules of ethics, funders can't take control over the management of the case, and especially not over settlement decisions. Plaintiff control of a settlement decision is sacrosanct in all 50 states under the rules of ethics. And also it's generally understood that ultimately the client drives the case and instructs the lawyers. And the lawyers also are subject to a duty of exercising independent judgment. So a lawyer can take advice and listen to the investor, who usually has very seasoned lawyers and staff, but at the end of the day, the lawyer has to stand up and disagree if that's their judgment call. The other issue that sort of hems in or limits how active a funder can be or wants to be is that in some states, the analysis of whether or not you are violating the champerty rule may hinge on control. So it may be the case that if you are controlling the case, then your funding is champertous, and if you're not, then you're not. And so there's a little bit of a game of funders saying, well, we are providing input and influence, but not control. And then there's a risk factor for the funders, as I alluded to, which is that if you become very active, and especially if you enter into the control regions, there's at least one federal case that says, well, under our at least jurisdiction, that makes you the real party in interest. So you actually become de facto a party in the litigation. And that's something that is not advisable. It subjects you to discovery and all kinds of other things that funders probably want to stay away from.
Interesting, thank you. The other question we were asked to address is, what is the difference between case funding and cost insurance? And I'll answer that only because this comes up quite a lot in the litigation in England and Wales, where you have to really seriously take a look at the risk of loss. And those are really two distinct things, at least in the English litigation system. In England, typically, litigants will have what they call after the event insurance. So they abbreviate it as ATE. And it's really important to have that, because the cost of litigation can be driven up if you consider experts, disclosure, which we in the US call discovery. There are a lot of things that come into play, and of course, the other side's lawyers' fees. In other jurisdictions, it comes up in litigation, but it's in many different countries, like let's say, as far as I know, in the Netherlands and in Germany, they don't really have after the event insurance, and it's not really required. But there is a real distinction between the two. Okay, we're just about at the point where we're supposed to end. Let me just take a look to see if we have any questions queued up in the chat. I don't think so, which is a good sign. I'll be around in and out of different networking over the next couple of days. If anybody has any questions, please do let us know. Please, everybody, do take a look at Maya's article. I looked at it before, and it has a lot of information in there. I think it's really good.
Fantastic.
And so thank you, everybody, for joining our panel. Thank you to the organizers for inviting us to speak. On behalf of Global Justice Network, I've really appreciated being here today. So thank you very much.
Thank you, and thank you, Melissa, for moderating the panel in a fluid situation beautifully.
Thank you very much, both Melissa and Maya.